There's a lot of chatter about the Department of Justice's position when it comes to suppressors in the National Firearms Act because of their filing in the George Peterson case down there in the U.S. Court of Appeals for the Fifth Circuit. There's a lot of questions about how can the Trump administration be pro-Second Amendment and yet defend the registration and taxation requirement of the National Firearms Act when it comes to suppressors down there in the Fifth Circuit in the Peterson case. Well, I think I know the answer. We're going to break it down when we come right back. Hey folks, I'm Mark Smith, host of the Four Box of Done, a proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and I'm proud to say the top voice of the Second Amendment in America. Thank you, 2025's Gundies Awards. All right, folks, so this is a quick one today, but I think it's an important video because there's a lot of confusion out there in social media and in other YouTube channels dealing with the Second Amendment as it applies to the coverage of this George Peterson versus United States case. This is the case down there in Texas and Louisiana involving whether or not suppressors can be regulated under the National Firearms Act of the 1930s. And just to give you the backdrop, and then I'm going to tell you what I think is really going on here, and I think you're going to be happy at the end of this video. The bottom line is this. In the case of United States versus Peterson, Mr. Peterson was convicted on a plea of guilty, I believe, for possessing an alleged suppressor in violation of the National Firearms Act because he hadn't registered it and or had a tax stamp. That's apparently the allegations. He pled guilty, preserving his right to appeal this charge on, among other grounds, the Second Amendment, arguing that the National Firearms Act, as applied to suppressors and to him, violated the Second Amendment, and this conviction for crime could not stand. This went all the way up to the United States Court of Appeals for the Fifth Circuit, and in an absolutely terribly reasoned three-judge panel decision by the three-judge panel of the Fifth Circuit, led by Judge Jennifer Elrod, they concluded that the National Firearms Act was perfectly constitutional as applied to Mr. Peterson and applied to suppressors because, among other things, suppressors were not arms. And because they are not arms, it does not implicate the text of the Second Amendment, which reads in relevant part, the right of the people to keep and bear arms shall not be infringed. Now, as soon as this decision was rendered, I explained this is clearly not going to stand. It's a terribly reasoned decision, 6 ways to Sunday. And eventually it got the attention of the United States Department of Justice under President Donald Trump and Attorney General Pam Bondi. After a series of requests to the Fifth Circuit basically saying, we'd like to reassess our position in light of the fact that Mr. Peterson's lawyers asked for a rehearing en banc to the entire Fifth Circuit, arguing that because the panel decision was so wrong-headed, the whole Fifth Circuit, all the active judges, should rehear this case of Mr. Peterson's on the question of whether or not suppressors can be regulated under the National Firearms Act and whether or not the NFA is constitutional. And again, the Trump administration initially basically just parroted the Biden administration on day one, saying, of course, it's constitutional, but then quickly after commentary on social media, including this channel, the Department of Justice under Donald Trump and Pam Bondi changed their tune and submitted documents saying, wait, Fifth Circuit, we need a little bit of time to assess this because President Donald Trump just issued an executive order talking about preserving and protecting the Second Amendment, and we need to reassess our legal position in the Peterson case because we may have gotten it wrong by embracing the Joe Biden view of the world. Well, it turns out that just a couple days ago, as you've heard on this channel and other places, the U.S. Department of Justice has made a major course correction, and correctly so, in that they have now filed a document in the Fifth Circuit Peterson case that makes a lot of fantastic concessions in support of the Second Amendment, including that, yes, suppressors are arms under the text of the Second Amendment, and therefore, if you regulate suppressors, you have to go through the full-blown Bruin analysis, including the burden shifting to the government to show there are long-standing, well-representative regulations on the books going back to the time of the founding to justify these regulations. That's the first thing. They also conceded that the Second Amendment protects the right to train, the right to practice with weapons, which is very good, and several other major concessions, including that you cannot ban suppressors. period, full stop, which is the no-brainer because I've talked about this even going all the way back to last year at an event for the Second Amendment Foundation, where I specifically explained in detail you can't ban suppressors because once they're deemed arms, you kick into the in common use test, and there's like over 3.5 million suppressors in the United States that is definitely going to be viewed as in common use, and you cannot ban them. So that's all good news. And the Trump administration basically in this filing just agreed with the 4-box of diner assessment. Now, with all that said, why are people criticizing the Trump administration for part of this filing? And here's why they're doing it. And here's why I think the Trump administration is making the right play here. The criticism is despite all those concessions, the second part of this brief filed by the Trump administration basically argues that notwithstanding the fact that suppressors are arms, the National Firearms Act, as applied to suppressors, is constitutional. And they make a whole host of terrible arguments, in my opinion. Clearly arguments that there's no way it's going to be upheld by the Fifth Circuit Court of Appeals. That's just my view of what's going to happen. So the question becomes this: why did the Trump administration go out of its way to basically say that, yeah, we understand we made all these major concessions, but we're still going to say in a court filing that the taxation and regulation, or I should say the taxation and registration requirements of the NFA as applied to suppressors is still constitutional under the Second Amendment? And why are we going to advance arguments that Mark's viewers on the 4-box of diner could probably jettison in a matter of minutes? Well, I suspect it's not a mistake. Why do I say that? Because remember, and this is very important to understand the strategy, this is a criminal case. It only involves one man, a criminal defendant by the name of George Peterson. It doesn't involve any gun rights groups. It doesn't involve the Second Amendment Foundation or the Gun Owners of America or the NRA or anyone like that, right? There's no members involved. It's a single guy, okay? Number one, that's important to understand. Number two, if the Trump administration came out and said, we agree entirely that the National Firearms Act as applied to suppressors is unconstitutional under the Second Amendment, what would happen? What would be the consequence of this? So again, if the Trump administration says that this law as applied to Mr. Peterson is entirely unconstitutional, what happens? What are the consequences of that? The answer is the case would be over. It would be dismissed. Now, we don't want that. If you support the Second Amendment, you do not want the Peterson case dismissed today. And you may be like, what are you talking about, Mark? Why would you say that? Let me tell you why. Remember how I teach you that every case, every legal precedent, every win out there is another brick in the wall to support the Second Amendment if we win? Well, every brick that rules against the Second Amendment is a brick the enemy can use. Right now, as we sit here today on Memorial Day weekend, in the year of our Lord 2025, on the books is what? Is that 3-judge panel decision against the Second Amendment in the Peterson case. If the Peterson case ends today and is dismissed on the grounds that the Trump administration says that this is an unconstitutional law, it means that the Trump administration and Mr. Peterson's lawyers have agreed entirely that this case was wrongfully brought and Mr. Peterson should not be convicted, and the case goes away. Well, that's very good for Mr. Peterson, and we hope ultimately that's the answer for him. Of course we want him to win. But with that said, if your goal is to get positive precedents for the Second Amendment and to avoid bad precedents against the Second Amendment, do you want this case of Peterson to be dismissed today, right now? No, you don't. You don't. Why? Because if you dismiss the case today, that terrible anti-gun, anti-Second Amendment decision with terrible reasoning by the 3-judge panel of the Fifth Circuit in the Peterson case from several months ago will remain on the books. It will be a precedent that can be used by the anti-gunners all across America in suppressor cases. So that has to go away. Does the Trump administration recognize this? They clearly do. Do you know why I know they recognize this? It's not because of any sort of secret information. It's because in their brief to the Fifth Circuit Court of Appeals, right here, right now, they specifically agree that the panel decision was wrongly decided and that the panel should reconsider and rehear this case in light of these new arguments by the Trump administration. Basically, the Trump administration, in its filings, got the ball to the 5-yard line, if you will, and then paused to make sure the case does not become moot. Because if the case becomes moot, the case goes away, because under Article 3 of the United States Constitution, federal courts are only allowed to hear cases that are actual live controversies. That's because the text of Article 3 of the U.S. Constitution, which governs the court system in America, refers to cases and controversies that federal courts have jurisdiction over. If you do not have a case or controversy, federal courts don't have jurisdiction to act. And if Mr. Peterson and the Department of Justice all agree that Mr. Peterson was wrongly convicted and wrongly charged under the National Firearms Act for possessing an unregistered suppressor without a tax stamp, if they agree to that today, that case becomes moot. It's no longer a case or controversy. The Fifth Circuit loses jurisdiction to hear this case. It goes away, and that terrible reasoned decision from a few months ago remains on the books that can be used by anti-gunners against, among others, the Trump administration. Which is why I suspect what's going on here is the Trump administration, again, said 90% of what they said is very good. The last 10% was, as I explained in my prior video, a half, in my opinion, it appears to be, now maybe I'm wrong, but it appears to me, in my opinion, to be like a half-hearted sort of pass the smell test argument that the NFA, as applied to suppressors and to Mr. Peterson, is constitutional under the Second Amendment, and they said just enough to make sure that there's still a controversy, because Mr. Peterson is still convicted and can theoretically still go to prison and all this kind of stuff. He can still be penalized for all this stuff if the conviction is upheld. So you still have a case or controversy. There's still jurisdiction here by the Fifth Circuit to continue to hear the case and perhaps change course and get rid of that terrible anti-gun, anti-Second Amendment decision that was poorly reasoned by that 3-judge panel. So I think that's exactly what's happening here. So when you see on social media attacks like the Trump administration and Pam Bondi sell out the Second Amendment because of this position in the Peterson case, not true. Now, they appear that way on its face. So to the uninitiated, to the sort of inexperienced in this area, that may be how it appears. And that's understandable, because why would they know any of the sort of detailed analysis that I know? How would anyone know this? You're not supposed to know this unless the Supreme Court bar matters to you, which it matters to like a few hundred people in America or whatever it is. But the truth is, this is, I suspect, what's really going on here. So weirdly enough, the fact that the Trump administration argued that the NFA, as applied to suppressors in this particular instance, does not violate the Second Amendment is actually the pro-Second Amendment strategic position to take. Because by arguing that and doing it kind of in a weak tea fashion, just asking the Fifth Circuit to knock out the NFA as applied to suppressors in all respects, you're ultimately pushing the Fifth Circuit, which is a very good court for the Second Amendment. It's a very strong court. And frankly, in my opinion, I would prefer for the Fifth Circuit Court of Appeals to be the U.S. Supreme Court and the U.S. Supreme Court to be the Fifth Circuit. We'd be better off, in my opinion, in America. But alas, the Supreme Court is the Supreme Court and the Fifth Circuit is the Fifth Circuit. But if there's any court in America, I would want to reassess the constitutionality of suppressors in the NFA, it would be the Fifth Circuit Court of Appeals, which is exactly where this Peterson case is pending. So again, I don't have any insight or inside information or anything like that from how the Department of Justice is thinking about it, but kind of looking at what's going on here, assessing the papers and the arguments being advanced, I suspect this is what's going on. Again, I could be wrong, but I'm just telling you how I see it. I think this is all very good for the Second Amendment, and I think there's a lot of strategic reasoning going on here. But again, only time will tell. By the way, folks, before I wrap up, I want to let you know I have a new article out that's not very long. You should definitely check it out in News 2A. I'll put a link to it in the description below about why Congress should remove suppressors from the National Firearms Act. It gives you the constitutional arguments to explain why registration of suppressors is unconstitutional under Supreme Court precedent, and also explains why the taxation requirement of suppressors is unconstitutional under the Second Amendment. So it's not very long. It's maybe like 900 words. I kept this nice and short so you guys can read it quickly. You'll have the arguments, you'll have the analysis, but I'm pretty much sure I'm completely correct on this. And I think the judges that care about the Constitution would agree with Mark Smith on these kinds of questions. In fact, then Judge, now Justice Brett Kavanaugh, basically has already corroborated a lot of the views here in that article in News 2A out of New Jersey. So definitely check out News 2A out of New Jersey. If you're not a subscriber or looking at their work, you should definitely be doing that. And also make sure specifically you look at my article on suppressors in the NFA. I think there's some really good stuff that you can use out there, and feel free to take it and make it your own if it's helpful. So there you have it, folks. Hope you enjoyed today's episode. Make sure you follow me on X at @4boxesdiner. Don't forget to subscribe to both YouTube and Rumble. I look forward to talking to all of you real soon here at the 4 Boxes Diner.
Orders up. Table 2A.